Okay. Let me just very briefly introduce the moderator to this panel. This is Vikramaditya Khanna, or Vic as we call him, or the Vicinator as sometimes we call him. He's a professor at the University of Michigan Law School and a dear friend of the program on the legal profession, and we work together on many projects. Vic.
Thank you, Professor Wilkins, and thank you everyone for coming today. We're all very much excited about the panel today, especially after such a wonderful panel to start us off this morning where we discussed disruption in the legal services markets and disruption more generally. And of course, one of the concerns that was addressed, or one of the issues that people discussed, was what role regulation of the legal market has in impacting innovation and disruption in that space. And luckily for our panel today, we have a global panel of regulators and experts on regulation of the legal services markets. Directly behind me on the giant screen is Chris Kenny, who is the inaugural Chief Executive of the Legal Services Board in the UK. He's held a variety of very senior government appointments in the UK and other appointments, including at the Association for British Insurers and as well as Oftel's Director of Regulatory Policy, in charge of putting in place ombudsmen. Following him will be William Hubbard, the incoming president of the ABA, who is also on the board of directors for the World Justice Project, and will discuss with us some of his plans for his presidency at the ABA. To my immediate right is Christina Blacklaws, who is Director of Policy with Cooperative Legal Services and is responsible for external engagement and strategic policy direction. To her immediate right is Andrew Finklestein, who is Managing Partner of Jacoby and Meyers, a very well-known and respected litigator, who will also be talking to us about his expertise in litigation in this space. And finally, to his immediate right is Ian Todd, who is Chairman of Deloitte Legal. Deloitte has 1,200 lawyers in 55 countries, making it one of the largest non-law firm law firms there is. With that, I will introduce or hand over the panel to Chris Kenny. For those of you who do not yet have Chris Kenny's slides, both Brian Fong and Hakeem Lagdar have them printed out for you. Just raise your hand and they will bring them to you. So without further ado, I hand over the floor to Mr. Kenny.
Vic, thank you very much. I have to say this is rather intimidating, knowing that what I'm looking at here is a picture of the panel and everybody else is looking at a giant version of me. I normally agree with David on nearly everything, but I think the audience actually might have found having the slide projected and just hearing my voice better than seeing a celluloid version of me on the big screen. But nevertheless, I will make the best of it. The first thing to do is really to commend David and colleagues at the PLP for running this conference. The number of academics who look at the area of legal services as opposed to the law per se is really very small. The number of those who do it from a basis of equal expertise in the law as well as equal understanding of the legal services market is even smaller, and I suspect that virtually all of them are in the room where you are at the moment, and perhaps there are one or two others watching online as well. But the work the PLP has done, I think, in getting interdisciplinary dialogue between business and law, an equal understanding of the value of law as a liberal profession and the value of law as a business discipline, I think is almost invaluable. So I'm really frustrated that family illness is stopping me being there in the flesh for the discussions over coffee, which are always just as valuable as those which happen around the panel table. What I'm going to talk about is first of all just a little bit by way of context setting about the market in England and Wales from a very high level, and I guess Christina might then come in with a few war stories of what it's like nearer the coalface. But I also want to spend a lot of time talking about what's actually happening in the market as a result of regulatory change, but not only regulatory change, and importantly also talk about what's not happening. Because I guess one of my core messages, as much to internal British audiences as to those in the States or elsewhere, is really to bring dramatic news that Western civilization has not ended. The rule of law has not been abolished. Law firms up and down the country are not being taken over by supermarkets or DIY stores or garages or anybody else. what we are moving into is a world where disruptive innovation, in the way that Clay, I guess, has described it earlier, hasn't yet happened, but you're seeing a significant sharpening of competition and the creation of conditions in which disruptive innovation may happen in future in a way that wasn't foreseeable a few years ago. So I'm going to end up really getting into a little bit of what next, what might happen next, what part regulation might have to play in creating those conditions. If you flick on to my slide showing a graph of the size of the UK legal market, you might think this is a story of success, even allowing for inflation and a little bit of a blip 2007, 2008 for reasons which are obvious. You're seeing very steady, sustained growth in this market, a doubling in size of the market effectively since 1997, and similar levels of increase in employment. So the sector as a whole in the UK employing around 300,000 people, of whom round about half are professionally qualified. A significant amount of that growth has come from a growth in UK exports of legal services. That's up from about £1.9 billion in 2005 to £4 billion in 2011, which is the last year we've got figures for. So overall, actually, you've got a picture there of a sector that looks in rude health, and very interestingly, a sector not too impacted by the global economic crisis starting in 2008. It may simply be that what's bad news for the rest of the economy, to some extent, can be good news for lawyers as they help people deal with the consequences of a slowdown. Who provides that market? Well, as you would expect, solicitors firms responsible for the bulk of that activity. Around 60% of the turnover of UK businesses comes from solicitors firms. 20% come in from other parts of the legal profession. Clearly, the English bar in particular has got an international reputation in all kinds of areas, not least in mediation work. But I think the most interesting part of that diagram is the 20% of income coming from unregulated legal businesses. Now, the ability to be an unregulated legal business has existed in English law forever. There are only 6 activities which you actually have to be qualified to undertake. And they're a pretty bizarre list: conducting litigation, rights of audience in higher courts, probate services, some aspects of the conveyance in the house purchase process, notarial services, and swearing an oath. But that leaves an awful lot of space for information and assistance for individuals by unregulated providers. Really, most advisory work could be done legally by people who aren't qualified. And while that's always existed as a theoretical possibility, you're now increasingly, for example, as the management of human resources becomes more professionalised, as intellectual property agent work becomes more professionalised, seeing people beginning to develop services there. And of course, also a large part of that 20% is accounted for by legal process outsourcing. Now, does that mean that happy days are here again? There are no problems? Absolutely not. Because while it is fascinating to sketch out what the supply side of a market looks like, what's much more interesting is to ask the question, is this serving the needs of citizens? Is it serving the needs of consumers? And the answer there is actually profoundly disturbing. What we know from our research is that 1 in 3 consumers don't get the legal help that they need at the time they need it at a price they can afford. And my personal guess is that that figure is understated rather than overstated. Work which Pascoe Pleasance and Nigel Balmer from UCL did some time ago now showed if you plotted access to legal services against income, a U-shaped graph. In other words, if you were really poor, if you were a welfare benefit recipient, actually there was a safety net there, maybe not as generous as some of us would like, but there was a safety net. If you were a higher rate taxpayer earning, say, £45,000, £50,000 or more, while you'd still be very cautious about accessing legal advice, actually there were services there you could afford. But the bulk of the population actually isn't at either side of that U-shaped graph. They're in the middle. And in the middle, basic rate taxpayers in the UK have a real problem about access to services at a price they can afford. But actually the problem goes deeper than that, because it's not a case simply of individual consumers, it's also a case of problems for business consumers as well. Our research showed 4 out of 5 small businesses don't get the legal advice they need when they've got a problem. What do? Well, some of the time they consciously decide that the ostriches have got it right. Approaching the law is so scary that they run away, and they consciously decide to rely on something they vaguely remember reading in a book some time ago. They rely on a conversation they had with a bloke down the pub the other week. They know, half of them know, that legal advice is very important in setting up a small business. Next to getting capital from the bank, probably the most important input you need when you first hire staff, when you first fire staff, when you get your first premises, when you first register your first IP innovation, whatever it is. But only 13% of them think that lawyers offer value for money in that space. And a small business doesn't think that. That says to me that the problems of the legal market actually aren't just its own problems, but the problems for the wider economy as well. And therefore, the case for some kind of supply-side reform to ensure that social and economic need is met is actually pretty overwhelming. Let's turn now to, against that background, what's happening and what's not happening to make that supply-side reform happen. I won't go through the long history of legal reform in the UK from Office for Fair Trading report, the Clementi report, the Legal Services Act, but I guess that 2007 Act introduced 3 big changes which my board has been in the forefront of turning into action. The first, independent regulation, making clear that regulation is wholly demonstratively independent, both of the profession and of government. And I do dwell on both halves of that sentence, particularly in continental Europe. I think there's a sense that because the non-executive members of my board are appointed by government, somehow that means there's been wholesale nationalisation of the legal profession and lawyers' independence is compromised. Absolutely nothing could be further from the truth. Yes, government does appoint the non-executive directors. It can do so only with the agreement of the Lord Chief Justice, the most senior judge in the UK. Once it's appointed them, it's actually fearsomely difficult for them to be removed. In practice, there'd need to be actually probably not just the committal of a criminal offence, but a pretty flagrant criminal offence. I always like the idea of concepts like gross moral turpitude or malfeasance in public office, because they always sound a bit more fun than just mere corruption. But really, so long as the board does not act in a criminal way, it is as independent of government as it is of the profession. Getting that level of public confidence, which can, to my mind, only emerge from independence of regulation, has been crucial. Second point is actually improving the service of the legal regulatory machinery to individual consumers through having a legal ombudsman who can determine individual disputes. One of the drivers for change in the UK was that the profession had over many years really failed to address consumer issues. quite often, because it saw any admission of failure on a service issue as necessarily an issue of professional conduct and discipline, and therefore shutters went down, barricades went up. The simple letter to say, sorry, we got it wrong, let me write a nice letter of apology, let me maybe make a pro bono payment of £20, £50 or whatever, just didn't happen. The ability of legal ombudsmen to enforce judgments without raising that kind of existential threat has been crucial. And actually there's some evidence that it's already had exactly the right effect in making firms resolve complaints better first time around, so they go nowhere near the ombudsman in the first place. But I guess the element of the reforms which has attracted most attention is the development of alternative business structures, where we are knocking on the door now of 300 firms being approved. Where did they come from? They came from a report from the UK Competition Authority saying there's something a little bit odd about this market, a market where 99.9% of the population are not allowed to own the business. And that, I think, is quite an interesting statistic to play with. Maybe I'm not a lawyer, maybe I've never understood it, but it seems to me that actually it's the people who want to justify only 0.1% of the population being allowed to owe something who have the case to make, not those who think the right should be universal. We can maybe get on to some of the theoretical arguments later. Let's look at what these 290 firms are doing. The only survey of any size which has been done up till now, although I know one or two people are working on it, is work we did back in July with a sample size of 64 of them. I think there was 64 at the time out of around about 200. And what's interesting is there is no great pattern of revolution within this. The heading on the slide said alternative structure, similar business. And I think that's right. Most of the people who responded to the survey were existing firms who had changed their status. Around about 77% of the firms who responded were already regulated by one of the licensing authorities. 15% were brand new. 9 or 10%, the remainder were offering some legal services but outside of regulation. And the motivation for becoming ABS varied. Around about a fifth were very consciously looking for access to external capital. But the largest number, and they're the ones at the bottom left-hand side of that slide, were people who were looking to bring non-lawyer management expertise within the business. Some of them using ABS directly, some of them were already in the halfway house of being a legal disciplinary practice in order to achieve that. And what you find in the various other slices of that pie chart were people basically looking to get some management advantage, either to improve succession planning, to facilitate a restructure, to project themselves into different parts of the market. Some of them in-house advisory services looking to offer services to the public, but no great common pattern, nobody saying we are the great disruptive innovators coming to pile in. Basically a lot of people looking to do existing legal services but better, sharper, in a new way, and maybe with just a little bit more competitive edge and attitude than their competitors. And I think that point is really rather important to stress, if only to go back to what I said right at the beginning. There were, I know in the US, but also other jurisdictions, and indeed in England and Wales, genuinely held fears back in 2007, 2008 about the potential impact of ABS. And all the evidence so far suggests that most of those fears were actually urban myths, maybe myths sometimes propagated from self-interest, maybe from genuine lack of knowledge and uncertainty. What were the kind of myths? First, that First, that vulnerable customers in particular would suffer. People would only cherry pick profitable work. Our survey suggested that wasn't the case. Virtually all of the respondents, 91%, said they were serving the same group. Actually, most of the rest said they were seeking to broaden the range of consumers rather than narrow it. Well, okay, you might not narrow your consumer base, but you might offer them rather less. Again, 83% of our base said there was no change at all to the areas of law in which they provided service. And again, most of the rest said they were looking to broaden their base. ABS will lead to wholesale mis-selling. Mis-selling really there in the financial services sense of the word, where the UK's history in relation to a number of personal finance products isn't great. Also in utility markets, there's a history of consumers facing high-pressure sales tactics to buy dodgy products which they don't quite understand and where they find exit difficult. Again, our evidence suggested very, very little change in marketing strategies from the bulk of the firms, although I think you will see a degree of greater professionalisation in marketing in some. Standards will decline because of cost cutting. I think people really started from the base that they couldn't envisage people providing services in a very different way to the way they have been historically. Therefore, any cost cutting would need to lead to a decline in service. I think this is really quite interesting. In terms of failures in consumer service, the evidence suggests at the moment that ABS firms do rather better than traditional firms. There's a very nice statistic. Mainstream law firms have to keep a record of the number of complaints. About 1 in 4 of those complaints don't get resolved and end up finding their way to the legal ombudsman. In ABS firms, that figure isn't 1 in 4, it's 1 in 10. Real suggestions that those who are coming in with a different model have got a sharper consumer focus, and a sharper consumer focus that actually leads to material change when things go wrong. But I guess the core fear is that there would somehow be a race to the bottom, and not simply poorer customer service, but actually lower ethical standards. As new entrants came into the market, stockholders would profit before public interest. You know, I'm not going to sit here and say nothing has ever gone wrong in any of those 290 firms, and nothing ever will go wrong in any of those 290 firms. But the fact is, at the moment, only one ABS license has been removed. There's no evidence at all of standards being lower. And actually, when you think about it, there are actually very good commercial reasons why that shouldn't be the case. If I pick slightly on Christina and she can retaliate, if Christina's business were really to lose its moral compass, actually it wouldn't simply destroy itself when the regulator took action, but it would add to pressure on the rest of the group of which the legal business is only a small part. There's a financial services group, there's a retail group, there's a very large funeral business. A lot of the other new entrants actually have very large, powerful, important brands to protect. The way they will protect that when they enter the legal business is to be absolutely scrupulous in their professional standards. The ethical imperatives that come from the professional training of the lawyers within the business absolutely align with the ethical incentives and the commercial incentives of stockholders within those businesses. Will things work out perfectly on every occasion? They won't, but to my mind, there is no difference in either kind or degree to the kind of temptation that would face an ABS to misbehave than there is to the kind of things that we know can and do happen in some more traditional law firms. Only a small minority, but it's because it can happen in that small minority that regulation exists altogether. So what I want to paint for you really is a picture where change actually begins to look rather more organic rather than revolutionary. The number that I didn't put on the slide, which comes out of our research, was that 41% of the respondents, when we said, how are you different to existing law firms, said, you know what, we're not that different at all. A third of them, and you see evidence from that in the figure I quoted about complaints, did say they thought they were different because of the consumer focus. But what you're beginning to see, I think, is a range of firms having a new strategy available to them, which they can use to begin to adapt their offering, rather than necessarily, at the moment, moving into revolutionary change. But that isn't to say all we've done is rebadged the deck chairs on the Titanic. The market is changing. In the small business space, you're beginning to see the development of subscription services. All you can eat legal advice for a set fee per month or per year. You're beginning to see significantly more use of online services, particularly around divorce, an area which we're researching at the moment, also about wills, also use of automated documents, and more generally and related to that, the ability to unbundle and rebundle services. So consumers who are perhaps prepared to self-service to some extent will nevertheless be able to access a level of advice they need where they feel a little less comfortable. And again, Christina's got some, I think, interesting examples from her own firm which she might want to talk about. We're seeing increased use of fixed fees, which seems to be only a good thing from the point of view of giving consumer certainty. I know Richard Susskind is talking later in the conference. I always steal one of Richard's best jokes when he talks about the incentive properties of hourly billing. I once heard him say that he and his wife had finally persuaded their teenage daughter to clean up her bedroom. And with bad grace, she'd accepted and said, oh, all right then, but how much are you going to pay me? And he said, oh, I don't know, I thought maybe £5 an hour. Oh, she said, I thought you wanted me to do it quickly. So I think people are going to look for a degree of certainty of billing, and that's starting to emerge in the consumer sector, just as corporate purchasers have been more aggressive in asking for it at their end of the market. We're beginning to see, I think, some really interesting advertising campaigns. There's always been a degree of TV advertising in the UK around the personal injury market. What we're seeing now, again from Christina, but also from other brands, including networks of traditional firms, actually, quality solicitors in particular, is TV advertising designed actually to build access to justice and to build brand, rather than simply about being immediately revenue chasing. And that's quite interesting. We're also beginning, as David Clementi foresaw, to see the development of genuine multidisciplinary practices. Most people, I think, don't wake up in the morning saying, I want to buy some law today. They wake up saying, I've got a problem about house purchase. I've got a problem with my neighbours. I want that problem resolved. I want this bit of advice about how I develop my business in its entirety. The label of the professional from whom they seek then is actually pretty irrelevant to them. And the more they can find one individual or one organisation that can meet the totality of that need to resolve the problem, the better. That's the reason why we've been so keen to push MDPs really to build up consumer service and small business service. And we're also seeing some corporate entry. We're seeing it from a range of really quite interesting people. My favourite is British Telecommunications, who in my past life I regulated as a communications regulator. They've entered the legal market because it dawned on them that if you are a national telecoms provider, your in-house legal department spends a lot of time dealing with personal injury work because your engineers run into vans or they fall off telegraph poles. Why not use that expertise to serve other businesses and even serve the public as well? But you're also seeing entry from people like the Automobile Association, the largest roadside assistance provider in the UK, from various insurance companies as well. Taken together, I think that's quite an interesting picture of organic growth rather than revolutionary change. But it's organic growth which actually has been driven, I think, by changes in technology, changes in consumer confidence and demand, actually changes driven by the recession, quite as much as regulation. Regulation simply removed some of the obstacles to enable it to happen. It hasn't been the driver or sought to prescribe. Here I want to quote one or two more examples. Brilliant Law, one of the big providers of subscription advice to SMEs. Stobart Barristers are a road haulage firm, would you believe, that's seeking to find ways of directing members of the public direct to barristers who can now deal direct with the public in a way they couldn't before. Christina's firm interested in the way it's developing its staff quite as much in the way it's developing services. And yeah, the accountants are coming again. PwC Legal, the first of the big four to be licensed, but I would predict not the last. But I won't attempt to draw Ian on his firm's own intentions as we move forward. Now, this seems to me to indicate we are at a very interesting point. Is it a tipping point? Will we go further, or are we at a stage where we're going to find a new plateau after this stage of organic development? And I'm not sure. I think there are a number of things which do hold further development back. The first is this is a market where consumers lack power. The classic regulatory theory argument for regulating this market is one of information asymmetry. Laws are a credence good. You don't know the value of it until you've got it. You may not even know it for several years after you've got it. There isn't a lot of information out there about price, about quality, about others' experience. Not quite sure I can envisage what the legal equivalent to TripAdvisor would look like, although there is the beginnings in the UK of some price comparison sites which are getting here. So there's still a degree of passivity in selection, and that's true, I think, even at the top end of the market to some extent. General counsel are perhaps a little more aggressive than they were 5 or 10 years ago, whether that's because they're just that way inclined or whether they have finance directors with their hands up their shirts beginning to influence them, I'm not sure. But perhaps with the single exception of audit, you still get a degree of very, very long-term relationships in legal purchasing, which are really somewhat unusual compared to other parts of the economy. I think, therefore, that a real task for regulators actually not to operate directly on the firms and individuals they operate, but in the marketplace to attempt to raise general consumer literacy, to attempt to raise general consumer competence and confidence in order to help make the market work more effectively. What else holds change back? Governance and culture. The partnership model is great at avoiding disasters. It's not great at achieving innovation. It's not quite true, I think, that it necessarily means that firms move at the pace of the slowest thinking, the slowest acting member of the partnership, and having a break on the most enthusiastic wild man of the woods in any organisation actually is always quite an important corporate governance mechanism to have. But you certainly talk to investors in the UK and they say what you've got actually is a common governance model, which means that firms are actually kind of catering to the third quartile within the partnership group rather than the first quartile or even the second. Where does that resistance come from in the governance model? Some of it actually comes from general cultural resistance to change. It's generalizing very, very unfairly to say that all lawyers stick in the mud. By definition, they do not. They would not be able to cope with change in statute. They would not be able to cope with change in case law if they did. But there may be something about the fact that their subject matter changing so quickly makes them that much more risk averse than other people to alter the way in which they engage with it. And likewise, again, a very wide and very unfair generalization, but like all caricatures, there has to be some truth in it for it to be recognizable. A sense that law firms as a whole are significantly less developed in their management and business expertise than in their professional expertise. Now, it's absolutely not for me as a regulator or for ministers or indeed anybody else to say, let's scrap the partnership model and do something else. Let's dictate what the new culture of the law should be, and let's have some kind of national curriculum for business expertise. But it is right, I think, that a regulator that's concerned with access to services for the public does think about innovation and allowing a liberalised market, not simply to allow new entrants in, but actually to spur a competitive response from existing players. And to do that perversely actually quite often means that regulators need to do less rather than to do more, and to think long and hard about what's in their rule books and whether what's in those rule books is actually getting in the way of change and innovation rather than facilitating it. So regulation itself seems to me potentially to be a drawback to effective innovation. Why does that happen? Well, I think it happened actually because of the legacy of history. Regulation has been about based on the award of a professional title, usually, rather than thinking specifically about the level of risk which attracts to individual activities. And the result of that is that the level and nature of regulation is spread very evenly across all lawyers, really irrespective of the sophistication of the clients which they serve, the nature of the activities which they do, the robustness or otherwise of their firm's finances. There's also, I think, been an absolutely properly well-intentioned belief that to maintain confidence in the law, you need really pretty high levels of consumer protection intervention. Maybe purely directed at this area, maybe not deriving from the consumer protection, the anti-competition law elsewhere in the economy. What hasn't happened when people have devised those interventions is really analysis about the opportunity cost. What's the level of cost which those interventions generate? What's the impact in terms of opportunity cost on a firm as well as direct costs? What extent of innovation and change might be lost as a result of it? Is there a solution which says actually you can allow greater experimentation provided firms have got good systems and controls around an issue, and very importantly that there's proper redress for a consumer when things go wrong? And that's interesting because it also underlines a shift in the focus of regulation, therefore to firms, as much as to individuals. Of course, individuals go wrong. Of course, individuals who totally lose their ethical compass will, on occasion, need to be hauled up before the regulator, on occasion, stopped from practice. But quite often what goes wrong for an individual isn't down to that kind of, if you like, moral ethical failure in the individual. It's down to pure bad management. And regulators need to find a way of addressing that in a proportionate way rather than making the individual the focus of their activity. Now, at the moment, there's a debate going on prompted by the Ministry of Justice in the UK about the cost and burdens of legal regulation. And we've put in a document which you can see on our website called our Blueprint for the Future, really looking at ways in which regulation can get out of the way to spur economic growth, as I indicated earlier, not just for the legal industry, but also in the wider economy. We think there are issues within the control of the bodies who we oversee, which could make significant progress really rather quickly. I list some examples on the slide. I won't go into detail, conscious that time is moving on. But this shift in particular to entities and specific risk away from general ones, relying on general consumer protection and competition law and redress rather than rule making, and in particular shifting the focus of regulators to get alongside firms whose activities may create risks rather than attempting some general ex-ante prohibition, seems to me very important, because I think we start from a position where reform in the UK is no more than work in progress. We think the existing model in the 2007 Act, while it's been a big step forward, still falls short of what good regulation looks like in terms of proportionality, accountability, consistency, targeting and transparency. I talked about achieving independence. We actually think there's room to go further. Ideally, we would actually have a single regulator for all parts of the profession and all parts of the industry in the UK, where perhaps the only regulator in history to vote for our own abolition, because we think if that new body was created, there would be no need for an oversight body like the Legal Services Board. But to do that, the remaining links between the profession and regulators need to be broken to create a single real public interest regulator. And above all, we need to find ways in legislation to get this change to really focus on risk rather than plain vanilla requirements spread across the board. Where does that leave us by way of conclusion? First, things are changing, but they're changing pretty slowly. Are we going to see Clay's kind of disruptive innovation? Possibly, because some of the obstacles are going, but that change will come from outside regulation rather than within it. Regulators' processes need to change, so deregulation needs to happen. Why does it need to happen? Because the unmet need for legal services is still great. Innovation's got to be there to make that happen. And my core contention to leave you with is actually all the incentives for that innovation to occur actually are to make it occur ethically, just as they are for existing service providers to serve their market ethically. Thank you very much.
Thank you so much, Chris. Now I'd like to call William Hubbard to be our respondent.
Vic, thank you very much. Obviously, there's much to learn from the experience in the UK, and that's something that the American Bar Association will be studying in detail. This was a helpful seminar and presentation by Chris, and it is certainly something that will guide what we do going forward. We'll also be looking at recent changes in Singapore. We know that the Law Society of Upper Canada has asked for money to look at alternative business structures. So we see this movement across the globe, but it's not something as of yet that the American Bar Association has embraced, particularly the piece of alternative business structures. We know there's a lot to be learned globally. We know from David and others that we're all interconnected, and this is one small community of the world now. And with these changes, we know there will be a need at the American Bar Association level to re-examine past decisions of our House of Delegates and adjust our policies where necessary and appropriate. We do know that. Reducing cost to clients, using technology to increase the efficiency with which legal services are delivered, and working to overcome barriers to access to justice have long been part of the American Bar Association's work. The ABA remains committed to improving the delivery of legal services for all consumers of legal services, and particularly those who are underserved and those who are effectively shut out of our legal system, and there are many. But we must keep in mind three principles, and I heard Chris say that these three principles, these tenets, are not at risk in the new structure in the UK, but they are these, and these are the things that we keep in the front of our mind: public protection, the best interest of the client, and the professional independence of judgment. Regardless of whether we agree or disagree on how the practice of law is regulated and conducted in various countries, these principles are the foundation of our profession. As our conversation continues today, those principles must guide our discourse. The ABA has looked at all sorts of non-lawyer involvement in the delivery of legal services. It goes back 30 years. There have been 3 or 4 major commissions of the American Bar Association, and on each occasion, Susan, they've come forward with proposals and regulations that we thought might lead to some change. But to date, the House of Delegates of the ABA has been reluctant. It's had no appetite to adopt some of these regulations. I saw Andy Perlman earlier. He was the wonderful reporter for the Ethics 2020 Commission that looked at new business models for law firms, possibly some non-lawyer investment in law firms. But when it came down to making recommendations, the political winds didn't favor our going forward with anything that was too remarkable or too dramatic. But that's something that you said, Vic, early on. What do you hope to accomplish as president of the American Bar Association when my time comes? I've been at a number of these conferences, and they're great innovations and innovators. But I think what my role would be and what the ABA should be about is trying to connect the innovators with the practice and the professionals who are currently practicing law and the leaders of the bar. We've been operating too long in silos. The innovators have not had an appropriate conversation with the Main Street lawyers in the United States, to the extent that those people who populate the ABA House of Delegates, and they are the bar leaders of the various 50 states and the territories, have not seen the need to move forward. So it's going to require an education effort if we're going to bridge this gap and create the kind of culture and environment of innovation that many of us think is essential if we're going to bridge this justice gap in our country. And it is a tremendous justice gap. We know from previous studies by the Legal Services Corporation and others, 80% of the poor in this country do not have access to legal services. And if you take the poor and the middle class together, that number drops to 75%. It's a huge number. So we obviously are not doing what we need to do to make our profession more responsive and better so that it can better meet the needs of the public and the people who are underserved. I commend to you a recent study. It's not published yet, but it's in draft form. But there's research prepared and conducted by Rebecca Sandifer at the American Bar Foundation, who's also on the faculty at the University of Illinois. And it's very instructive and enlightening on how we approach this issue of delivery of legal services. Her studies indicate that the lower one is on the socioeconomic education scale, the less likely they are when confronted with a legal problem to even know there's a legal problem. The typical response of somebody the further down on that scale is, you know, life is unfair, I've never made it in anything I've tried to do, this is another piece of bad luck, so I won't do anything. The more you move up that scale, according to her research, the more inclined, if you have had more success in life, is to engage in some form of self-help. And I think that's where we see LegalZoom having a good bit of success in the way that they assist people through the self-help process. And then those of us at the top end some of us, not me, but others who are at the higher end of the socioeconomic and education level, certainly have the ability to attract the best legal services that money can buy. As David Boies has said, that portion, that segment of the population is actually over-lawyered. And we need a new business model for that segment, those segments of the market that are vastly under-lawyered and do not have access to legal services. I've just about thrown all my prepared remarks away because I want to make sure that all of the members of the panel have an opportunity to respond. 7 minutes left. Okay, let me cut through some of this and see. You know, we do have examples of innovation in our country that deserve further study. We know about Axiom. ClearSpire is made up of lawyers who work remotely using a proprietary technology platform that mimics a virtual office. We are listening to lawyers in the United States. There are many who ardently believe that any form of non-lawyer ownership involving fee sharing or investment with non-lawyers would undermine the legal profession's core values, but there are others, as I indicated, who are trying to shift the thinking and looking more broadly. There's one particular component of this I think that's really important to consider. We do enjoy self-regulation in the United States. The bars do. We regulate ourselves, but concomitant with that ability to regulate ourselves comes that duty to provide legal services to those who are the least fortunate among us. And so there is a self-interest piece that we try to do something about this justice gap, and we look to innovation, greater uses of technology, and new ways of doing things. And certainly, you can make the point that we're on the cusp of a great opportunity because there's never been a generation in law school and coming out of law school now that combines so elegantly the expertise and the use of technology with their legal education. And so we need to be looking to the younger lawyers. They will look at the way we do things as they look at me and my firm and wonder how I could be so tedious and slow about the way I practice law. There's a much better way of doing it, and I'm learning from them how to do it better. But we need to harness that entrepreneurial spirit of young lawyers, and we need to move ahead with innovations, and we need to adapt and adopt new rules when that is necessary. We do see examples of limited changes in regulations. We see the limited licensed legal technicians proposal in Washington State. They are taking a very cautious approach to the limited licensing of legal technicians, limiting the practice now to family court. But these limited license legal technicians cannot go to court and they cannot negotiate directly on behalf of their clients. So there are limitations on these kinds of innovative activities. We do know that the state of California is looking carefully at what goes on in Washington, and based on conversations that Elizabeth Chambliss and I had with the executive director of that bar last week, it wouldn't surprise me to see California accelerate the pace of this kind of regulatory reform so that we, not only in the field of legal limited licensed technicians, but also perhaps in non-lawyer investment in law firms. Let me just conclude with this. You all know much better than I the preamble to the Constitution. We, the people of the United States, in order to form a more perfect union, establish justice. It's the first thing in the preamble, establish justice. We do not establish justice if we do not fulfill our duty to provide justice for all. It's just words on paper unless we get about this business and do a better job. And it's not going to be solved if we continue to do business in the same way that we've done business for the last 50, 100 years. We have these breakthroughs you heard about this morning. We'll hear about additional breakthroughs and innovations. We need to be more accepting and willing to look at new opportunities if we're to fulfill our promise. Let's get to it. Thank you.
Thank you, Mr. Hubbard. And now I'd like to welcome Christina Blacklaws from Cooperative Legal Services.
Okay. Let me just see if I can. Slideshow from the beginning. Hey. There we are. Okay, ladies and gentlemen, I'm delighted to be here. Thank you very much for inviting me. I'm going to follow on, I think, from what Chris started to look a little more in depth at what's happening on the ground in the legal services market in England and Wales, to talk about what we're doing at the Co-op and perhaps particularly to address access justice, which is something about which I feel passionate, and then to ask a few searching questions as to what it might mean for you in 9.5 minutes. Okay, I'm going to go through this very quickly because, as you know, the legal services market in the UK is extremely diverse. In fact, we have 3 separate jurisdictions, England and Wales, Scotland and Northern Ireland, and I'm just going to concentrate on England and Wales. We have there an industry that's worth around about $40 billion, so it is significant in terms of our GDP. You'll probably think of our legal services market in terms of Magic Circle, those large behemoth multinational businesses that are based in the City of London, but of course there's more to our market than that, and underneath those large businesses set around 10,000 legal firms. The rest of our market is pretty much a cottage industry. Really about 25% are sole practitioners and 85% are firms with under 4 partners. So it's a really quite fragmented market. And into this market, we bought the ABS, the brainchild of Clementi, Legal Services Act 2007, but actually not implemented until 2011. Of course, we have 219 counting ABS at the moment. I wanted to highlight something that actually comes from Chris's LSB research. To start to, and this will be a theme, address some of the concerns around ABS. The research showed that we were more productive and innovative than traditional firms, but better at resolving complaints and had significantly increased the market share. So we're not talking about cannibalization, we're actually talking about growing a market, offering services to people in a way that they haven't been able to access them before. So who is investing? I'm not going to look at traditional firms and what's going on there because that's not really where the interest is. I think we need to look at new entrants and what's happening. So I've divided this up into 4 categories. which helps me to think about things. And I'm going to talk really in the main about the consumer legal services market, which I include services to small businesses. There are over 4 million small businesses in the UK, and as you've heard from Chris, they're really woefully underserved. And some of the biggest investments that we're having in our market relates to process-driven areas where legal services have been largely commoditized, and such as personal injury, and in road traffic accidents. So let's have a look at some examples. So private equity. Now, we're talking about millions upon tens of millions of dollars coming into this market at the moment. Smedvig Capital owns the largest conveyancing practice in the country. Conveyancing is our word for real estate. Jute Street owns Paribus, and Paribus is a firm which specialises in producing white label services and has a turnover of over $170 million. Palamon has invested in a national legal franchise called Quality Solicitors. Quality Solicitors has about 150 member firms. Work very closely with John over there, and they have put a lot of money behind them. What about the insurers? Now, this has partly been driven by a ban on referral fees in the UK market, which was brought in at the same time as the removal wholesale of legal aid. And the aim was obviously to reduce the number of claims, but what's happened is that insurers have invested directly into law firms. They now have their own captured law firms, and they own them either wholesale or in joint ventures, and that is quite an interesting development in our market. With regard to the disruptors, we've already talked and heard from John. BT, Chris has already mentioned, but there are others in that space as well, people who are offering legal services in a way that hasn't been part of the market before. And then the consolidators, and Slater & Gordon, first global IPO from Australia back in 2007, and since then have moved in a very major way into the UK. So they have created a national network, spent much more than $200 million in doing so, and they are really ones to watch for the future. But I want to just have a quick look at Quindell, because Quindell, I think, is something that you won't have here, and it's an example, say, of vertical integration. So what Quindell have done, and this is a road traffic accident enterprise, so they have captured it from start to finish. So they have the claims management handlers, two of those they bought. Then they bought the solicitors' firms. They went on to buy mobile doctors so that they could cover the medical reports that were needed. And last but not least, they got the billing captured. So they have absolutely end-to-end captured the market. A lot of money. As I say, I've added up, my maths isn't great, but that's over $220 million. Very quickly about the Cooperative. These esteemed gentlemen here, the Rochdale pioneers, established the Cooperative Group in 1865. And Cooperative Group has a number of different businesses, which are all in one family, a total turnover of over £20 billion, $20 billion last year, more than 100,000 staff. And legal services is one of the things that we do. But I think fundamentally what's important to understand about us is that we are a mutual. We are owned and governed by our nearly 8 million members in the UK. And that gives us a very different perspective, brings something very different to the table in terms of legal services, and that is the ethics, the core values which dominate our business, We, in our legal services, ensure that what we're trying to do there is to bring access to justice to ordinary people in our country, as well as those who are the most disempowered and the most vulnerable. And so how are we doing this? We offer a full range of consumer legal services. We have about 630 people working in our business at the moment. Everything that we do is fixed and transparently priced. In fact, a lot of the stuff that we do is free. So we have 87 YouTube. We have a YouTube channel where we have downloadable PDFs and YouTube videos, which are how-to guides, telling people how they can do things themselves. And if they need a bit of extra help and support there, well, we offer them legal aid because we have the ability to do that for what's left in legal aid. And only then, if they need further help and support, do we offer them very transparently priced services, which are extremely good value modular services, so that they're always in control of their legal service access. 1 minute on what this means for you guys. So actually, ABS isn't limited to Australia and the UK. Although having said that, because we're talking about effectively organisations that are in jurisdictions that look a bit like yours here, I think it's probably of more interest. But of course it is under consideration. Hong Kong, Singapore, across Europe there are a whole range of opportunities for businesses to have external investment and non-lawyer ownership. So it's becoming very broad. Of course, Ontario, as said before, has just begun a consultation. So can the US resist? Of course, there are potential benefits as well as potential risks. I'd say that the research from England and Wales, and we've had 2.5 years now of ABS, and what we've had, none of the people who drafted the Legal Services Act could have envisaged. But actually, as I think you might say here, the sky hasn't fallen in. We have had an increase of access to justice, an increase of consumer power, and services that actually meet people's needs in a way that they can afford. So this might be a really good thing for you guys, at least to be curious about, to understand what's happening on our side of the pond, and to look to see what the application could be in the United States. And you never know that the framework that we have that works on High Street UK may also be appropriate for Main Street USA. Thank you.
Thank you, Christina. And now I'd like to welcome Andrew Finklestein, Managing Partner of Jacoby and Meyers.
Good afternoon. I stand before you as an attorney who is practices and accustomed to time frames, and if I go over my time frames, I could be sanctioned and actually have to pay money. So I'm not worried about that clock there. When the judge hits that gavel, I stop. I'm a litigator at heart. I try cases, a trial lawyer. We've heard a lot today, and thank you for inviting me to come. It's a great program, and this program is all about disruption. And I was asked, because I've commenced litigation that I think is a bit disruptive. And by no means do I mean any offense, Mr. Hubbard, the president of the ABA. The reason why we commenced the litigation, which I'll explain in a moment, is because the ABA has acknowledged over and over again that our legal system is broken. We've heard here over and over again that our legal system's broken, that the vast majority of the population that need legal services can't either afford them, don't know how to buy them. There are all kinds of regulations about lawyers' ability to communicate what they can do, cannot do. We heard from John about big law, small law. What I'm focused on really is small law and the consumer that goes to the small lawyer. That is where there's a tremendous broken system. So we sat back at Jacoby and Meyers and watched the ABA conduct its 2020 investigation, and over the past 20 years talk about breaking down the barriers to the law firm structure, because it's my personal opinion and my firm's opinion that one of the core elements that is broken and the structure that is broken is the actual ownership opportunities within law firms and their ability to partner or collaborate with non-lawyers. That silo that lawyers are forced to stay within prevents the innovation that can cure the very problems that are facing the legal industry. So rather than continue to wait, we chose and elected to do what we do best. We sued the 4 judges in the state of New York that enforce the disciplinary rules that prevent lawyers from associating with non-lawyers and partnering with them. There's a very specific rule, and only because there are, I believe, many non-lawyers here, it's 5.4. That is a rule that says there's an absolute prohibition, not allowed at all. It says lawyers shall not share fees with non-lawyers. Lawyers shall not practice with or in any form or any entity practice with non-lawyers. Absolute blunt instrument, shall not, cannot, never. It's my opinion and our litigation's opinion that that is absolutely unconstitutional. That an absolute prohibition on one's ability to associate with other entities, whether it be for profit or not for profit, is unconstitutional. It violates the First Amendment, freedom of free speech, and so on. This has not and won't, this particular litigation is the first time it's been commenced, but the question has not been, it's not the first time that courts have addressed it. One particular case that you may be aware of is Bates, which had a prior absolute prohibition on lawyers' ability to advertise. Said lawyers cannot in any way advertise. All they can do is put their name in the white pages, and that was barely allowed. So that litigation, the outcome of that was a very simple decision, which said it overturned a blanket prohibition and said that lawyers can advertise with regulation. So every state has their own specific regulations, which is a myriad of horrible rules, frankly, that are all masked to prevent the consumer to hear what really is going on and to protect the self-interest of the lawyers within that state. Again, my personal opinion. So we've commenced this litigation under the same theories and the same thoughts. We're optimistic because corporations have been found under Citizens United, I'm sure everybody's familiar with that, have the ability to have First Amendment free speech. So we sued, New York is broken down into 4 different departments. The presiding judge of each department is the one who enforces the ethical rules. We sued all 4 of them and said, you violate our constitutional rights. They're being represented by the Attorney General, Eric Schneiderman, in federal court in New York. Our initial complaint sought to overturn this specific statute. The answer that came in specifically said, you can't do this for procedural reasons. First, there's no harm, because I haven't actually partnered with somebody who's not a lawyer. How can you come forward and you haven't been harmed? You haven't been disbarred yet. So And actually, that was actually in their papers. And other things related to that, but basically the court dismissed it on procedural grounds. The core procedural ground was because you challenged 5.4, even if I overturn 5.4, there's laws in the partnership law, limited liability corporation law, all these other laws that will prevent this as well. You didn't put that in your paper, so I'm not going to decide this. We went up to the Court of Appeals. Court of Appeals it summarily said that's ridiculous, sent it back to the judge, Judge Kaplan, and said, give us a decision on the merits. Currently, our papers are before Judge Kaplan, Attorney General papers are there, and we're just waiting for a decision. I'm sure whoever is on the wrong side of that decision will bring it back to the Court of Appeals. Court of Appeals will then issue their decision, and I'd be shocked if it didn't then go up to the U.S. Supreme Court. But what we heard today is exactly what was in the papers of the Attorney General. Well, why can't they do this? What's so terrible? Why shouldn't this happen? And it was all couched in the three principles Mr. Hubbard outlined. Basically, that the profit motive somehow is going to affect lawyers' professional independence. That the sanctity of law has to be preserved. That the economic interests will conflict with a lawyer's professional judgment. We've heard from the UK, we've seen from Australia that that just doesn't happen. It's not so. That those absolute concerns that are there and are valid can be protected with appropriate regulation. And there's a whole host of regulation that can be imposed upon lawyers who decide to move forward and correct the problems in the small law world. Some practical instances of how this really plays out that many may not realize is, as John said, there's 400,000 solo practitioners who have put their time, energy, and their life's work into building something of value for them and their family. At the end of their career, they are absolutely prohibited from selling that practice to anybody who is not a lawyer. Can't happen. So what happens? There's a natural fall off of all of these firms, that the value that anybody has built and grown their life's works dies. I'll leave it to the people here to determine whether that seems fair or equitable. Those individuals, if they want to build their practice in any way, are completely restricted in their capital generation. They can only do it if they borrow money from a bank. It generally is rare to happen because banks, I won't get into the whole financing structure, but they can't go to their family member and say, invest in my firm like any other business, and we'll share the proceeds. So we've challenged these laws. We'll see what happens. I'm optimistic that at the end of the day we will do the work the ABA is reluctant to do, and that is force this change to happen. So with that, I thank everybody for the opportunity and the time.
Thank you, Andrew. And now I'd like to welcome Ian Todd, Chair of Deloitte Legal.
Thanks, Vic. Let me start by asking a question. If you go back 100 years ago and compare the Deloitte organization with the largest law firm in the world at that time, what would you have seen? Firm of accountants, firm of lawyers. Their lawyers and accountants, they would be attending the same meeting at the company. They were probably of a similar size back then, 100 years ago. So why today is the Deloitte organization 15 times bigger than the largest law firm in the world? Why is that? And why could that opportunity not have been reversed, the other way around? The most fundamental reason is that Deloitte is not just an accounting firm. We have a consulting practice that's $10 billion and that has tens of thousands of employees, very few of whom are accountants. They're professional consultants, been to Harvard Business School, lots of them. You know, we have thousands of people who have had legal training, including Harvard Business Law School graduates. We have economists, we have engineers. And many of those people are in partnership or equivalent roles and are in senior leadership roles in the organization. We look at it as acquiring talent. So why do we have such diversity of talent? Why is it fundamentally? The fundamental reason is that our mission is not to deliver a particular service. Fundamentally, our mission is to help clients solve complex business problems. So, for example, in the legal world, lawyers commonly help a client close a real estate transaction, negotiate it, close the purchase of a piece of land. So, no doubt, the technical, real estate, environmental law issues, all those kinds of things, contractual issues, all very important. But what if the client's real objective in buying that piece of land is to build a hotel resort at the seaside? What's the problem? I commend a video that Professor Christina has done about when you look at why people buy a good or a service, it's not about the attributes of the good or the nature of the service. It's about the reason they want to buy the service. So why is the client buying the legal service? Why are they needing professional advice? It's really to solve various types of complex problems. The world is infinitely variable. But if you fundamentally understand that, it changes your business. And it changes your attitude about what you need to do in order to help solve that client's problem. So our experience is that clients very much value a holistic approach to solving their problems. They too often, from other service providers, see piecemeal approach that lawyers, investment bankers, many others provide just a piece of the puzzle. They would prefer to have people work on their fundamental holistic problems. So 100 years ago, when a client said to his or her accountant, you know, you've been looking at my financial situation. Oh my God, I just realized I'm not making that much money, or as much money as my shareholders want me to make. And I'm losing market share of my product. I got a competitor who's doing a better job. You tell me I've got too much inventory. Like, can you help me? You know my company. Can you help me figure this out? And eventually, the penny dropped, and a number of smart accountants said, well, you know what? I've got someone, or I'm going to get someone in my firm to help you. That's where it started. So fundamentally, the disruption a lot that's being talked about in the legal profession happened decades ago in the accounting profession, because it didn't take too long before those few smart accountants who thought that way, that became the norm. And then clients expected it. All of a sudden, if you didn't have a consulting arm, it was a problem. If you didn't have, in our tax business, if you don't have PhD economists working on your transfer pricing issues, you're at a disadvantage. You won't get the work from the client. You won't do as good a job. So that fundamental innovation happened decades ago. So compare that to the legal profession. Why haven't law firms developed consulting arms? It could have, subject to a few of the discussions we're having here. Could have. Why haven't lawyers enough taken a holistic approach to client problems? You know, has the narrow approach to regulation actually prevented good service to clients and actually stood in the way of limiting opportunities for clients? So is it time really to revisit? I think a lot of this conference is about revisiting the nature of regulation and its potential positive impact of reform on client service, access, and actually enabling lawyers and law firms to open up the potential of this profession. This profession has among the smartest professionals of any other profession. And in my personal opinion, it's holding itself back. So I'm going to stop here because I would rather save David some time and save you some time before we have lunch. So I'm happy to chat anytime with anybody. We have a lot of thoughts about this whole area, and I want to thank David and his colleagues for putting this conference on.
Thank you, Ian. Now with that, I'd be delighted to take any questions that people may have of the panel or more generally about the proceedings thus far. Just raise your hands, and I'm sure the microphone will find its way magically to you.
I'm going to stay right here, so if you want to line up.
Okay, so you get to find your way to the microphone. Yes, John.
So maybe a question at large for the panel, because everyone might have a perspective on it. But when you think about the capital required to fuel innovation, and I would divide that between human capital, that I think Ian spoke eloquently about, and actual capital, which is, I think, what Andrew is pursuing in his lawsuit. Both are clearly required. Which do you think is most important to fuel innovation?
Actual capital.
I thought of it. By the way, Chris.
Actual capital. The human capital is we're churning out human capital over and over, and we can't deploy that human capital. There's such a overabundance of attorneys, and it's a true problem for people going to law school, and without the actual capital to figure out the most efficient way to deploy the human capital to cure the problems that we have, the cycle will continue.
Can I agree with that? Because I think that if you want to bring legal services to a mass market, then that requires external investment way beyond what most law firms can access, certainly in the UK, even if they get investment from their banks. So the ability to raise capital that we have in the UK, I think, is quite game-changing, whether that's through private equity investment or any other investment. That will make a significant difference to the services and the delivery of the services that we're able to produce.
I think we have to remember how big the legal industry is. It's $600 billion today, heading to $1 trillion in 2020. So in parts of that market, absolutely, real capital, investment money will make a significant difference. In other parts of the market, I wonder whether external capital is actually helpful. If you look at some of the experience of some of my competitors in our business who sold off their consulting arms, PwC sold it to IBM, and IBM was challenged 3 years later when the covenants ended up, most of the partners left. Why? Because the culture of a firm like IBM was a bit different from a professional culture. So that doesn't mean, however, that the business structure should be mandated. Let the market decide. There's a particular part of the market where capital can be deployed effectively to do all the things that many of our panelists have been talking about. Permit that, let it happen. If it's not, doesn't make sense to have external capital, let the firms who are playing in those fields decide that. Let the market sort out what's appropriate.
I'm going to put in a vote for human capital, just to disagree with the rest of the panel and get some discussion going. It seems to me that law schools have been great in churning out human capital in large numbers. They've been rather less good at thinking about human capital in a large number of different forms. And what is clear is if the kind of opportunities that external capital investment will generate are to be acted on, actually you're looking at a very different type of lawyer with a very different type, perhaps, of expectation of what his or her career might look like. Mr. Hubbard, I think, spoke eloquently about learning from junior members of his firm. I think when you hear from Richard Susskind later today, he will talk about the evolution of different legal roles as well and different career patterns. So clearly the external finance is important, but there's a role, I think, possibly for the educators in the room to think about different forms of human capital as one way to enable external investors and the profession to jointly serve the public.
Gregory Meyers. I'm a trial judge in Washington, D.C., and I serve as a fellow at the National Center for State Courts, which is the secretariat to the Conference of Chief Justices and the Conference of State Court Administrators. And in this country, unlike most, it's the bench, it's the judicial branch that governs lawyer practice and ethics. For this panel, and I'm very interested throughout the day, I pose the question, does the concept, the dynamic of disruptive innovation, can it apply to a regulator? Can it apply to an entity or an enterprise charged with public governance? I'm having a hard time seeing the connection because the mission of the regulator is created by a statute. It doesn't have the enterprise, the entrepreneurial possibilities. I'll stop right there.
Shall I kick off as the one regulator? I think it can, if your founding statute is right. Our founding statute gives us objectives in relation to the promotion of competition and promotion of access to justice and promoting the interests of consumers. They're not put in any hierarchy. They sit there alongside other important objectives about the rule of law, about protection of the public interest, about professional principles. It seems to me you can task a regulator with developing innovation alongside other duties, because the regulator, as much as anybody else, is subject to the rule of law, and we have the courts to act as a check on our behaviour. Were we to become irrational in giving one of those duties a weight that totally outweighed all of the others? Doesn't mean we don't occasionally have difficult conflicts to balance, but I don't think it's ultimately beyond the wit of man or woman to find a way to do it.
I had one comment. You see examples. Judge Lippman, Chief Justice Lippman in New York is leading the way toward a whole host of items that will tend to, I think, address this justice gap. One program is the training of non-lawyers. They're called court navigators, to go with unrepresented clients, litigants to court and respond to judges' questions. Now, the rule currently, as it's currently constructed, does not allow these navigators to affirmatively go in and make a case, but they are there to assist the court and make the process more streamlined and efficient, and give some guidance and support to the people who have legal problems. And again, one of the big problems, and this is not exactly responsive to the question, but I wanted to make it, is the failure of many people to even understand it is a legal problem. And that is a core issue that has to be addressed. And in one conversation I've had with an individual, and I thought it was just a terrific idea, why don't we come up with a way to use our public libraries all across the country? Even the smallest towns tend to have a public library, and have someone like an ombudsman or a navigator to have these questions asked and determine, is this a social services problem? Is this a medical problem? Or is it a legal problem or some other type of problem, and steer people in the right direction? So, there are a whole host of things out there. I don't think any of us want to put our head in the sand. There are some lawyers who do want to put their head in the sand. They don't want to change at all. But there's some innovation out there. I think the role of the American Bar Association is to accelerate that discussion and accelerate that innovation, working with the regulators to come up with things that make sense.
Fred?
This will be to Mr. Finklestein and Mr. Hubbard. My name is Fred Hopengarten, and I practice a very narrow, specialized area of law involving antenna zoning, which is federal preemption of local law, basically. My question was, in multi-jurisdictional practice, and I believe your firm is heavily involved in multi-jurisdictional practice, we've seen very little progress of the kind that you see in medicine and with the CPAs, basically with the professional engineers, the PEs. I think it's for $75 they can be licensed in any jurisdiction this year because they have a national organization. I'm wondering if perhaps Mr. Hubbard and Mr. Finklestein could address the question of why the American Bar Association or any national organization hasn't set up some sort of clearinghouse to deal with the question of discipline, because it seems to me that the principal reason we don't have more widespread multi-jurisdictional practice is that the individual states are taking the position that they cannot discipline people across a border. When last I checked, the internet pretty much goes everywhere, and I'm wondering if you'd address these questions.
Well, I can't speak on behalf of the ABA, but it's a core problem when regulators attempt to impose their will on private actors outside their state who aren't doing anything within their state. But there are some federal areas of practice which cross all state lines.
Perhaps you could explain to me, Mr. Finklestein, why it's necessary to be admitted separately in every U.S. district court.
You're speaking to the choir. I mean, I think it's ridiculous. So that's the whole problem with their network of rules. And I'd like to just go back to the judge's comment. What's perverse about not your question, but the situation is that the very regulators who are charged with the responsibility to enforce the ethical codes amongst lawyers and who have in fact created these ethical codes are the judges who have created an ethical code that is unconstitutional. So it's a challenge when you're going to the very party to say what you're doing to the bar is unconstitutional and you're the one who did it. So that's, I think that's why we've seen us running in quicksand here. But I think bringing it to federal court and ultimately letting it percolate through the system, we may see some changes.
Last question, Raj.
Yeah, hi, my name is Raj Abhyankar. I'm
I just wanted to make it clear to everyone that the American Bar Association can't force any regulator to do anything, but what we do is we do propose model rules of professional conduct, and that was the Ethics 2020 Commission and other things. And to the extent that we can get the support of those representatives in the House of Delegates, those rules become model rules and they're adopted and they're promulgated and distributed to the states, and the states then have the complete unfettered authority to accept or ignore those recommendations.
Yeah, my name is Raj Abhyankar. I want to revisit the first question where we talked about human capital versus actual capital. And I'm an attorney, a solo attorney that started my own practice. I've built it to a $10 million practice, and I've done so by reinvesting my partner profits into a software company. And so it seems to me that human capital is very important if you understand that human capital isn't just lawyers, but it's rather technologists. 3 people in a room, computer scientists, can do wonderful things. So it seems that the incentives to get the best talent from there requires a focused effort for the bar to organize itself, to incentivize its own members to create somewhat of an angel fund so it can reinvest its own profits into innovations in the legal space. And B, the question to me isn't more about human capital or actual capital, but the lack of incentives for an exit. To really get the top talent engineers of where I'm from in Silicon Valley, you have to have an exit painted to them. And without a foreseeable exit, it's very difficult to recruit the real talent one needs to build a legal innovation enterprise. So that's just my comment. And I'd like to hear your thoughts on that.
Goes to the core of my litigation. That's why the structure is broken. You can't attract the best talent when you can't structure the deal that is in the rest of the world. and the deal that has to be structured to bring on the best talent, I'm talking about non-legal human capital, is one's given a choice to come work for me or to go work at LegalZoom. They're going to go work at LegalZoom because of the upside potential of everything that flows through equity ownership in an entity. I cannot do that.
Yeah, I would argue even LegalZoom is in a bind. I mean, there's no way that it cancels its IPO. So the real talent looks at that and says, why would I want to work at LegalZoom versus a company that has a foreseeable IPO with no litigation risk? So the legal sector itself becomes entirely ignored because of that.
Right.
It looks like we're running a little bit short of time here, so I will call this session to an end. I would like to ask all of you to join me in thanking our distinguished panel here for their comments. And just a reminder that next we're going into working groups. There are lunches downstairs, right in front of where you kept your coats and your rollers, and then there are separate rooms for each working group. 2 downstairs, 1 on this floor, and 1 upstairs. Enjoy.